May I please, Your Lordship?
Just wait.
My lord, item number 1 of today's list, my lord.
Yes,
My lord, the conducting council is seriously unwell, my lord. So I'm sitting at item number 1.
one.
Yes, my lord. And Islam, he is seriously unwell.
No, this is for,
Mediation.
yes, mediation.
No, I'm not the counsel for the Islam. I'm just making a prayer on his behalf. That the
Mr.
matter be T.N. Srinivasan. E.N. Srinivasan.
E.N. Srinivasan, Learned Counsel, appearing on behalf of Mr. N. Islam, Learned Counsel for the petitioner, submits that Mr. Islam is unwell, therefore prays for listing of the matter after 2 weeks.
My lord.
Praise the Lord, list after 2 weeks. Huh?
Right.
May I please, Your Lordship? With regard to item number 6, my lord.
Huh.
My lord, otherwise is also in the mediation column, my lord. It's not a case of for the mediation, my lord.
We don't know, this has been identified.
My lord.
So,
So let the matter come after 1 week or 2 weeks.
Why?
my lord, in the admission.
who is for
column.
respondent?
My lord, state, my lord.
Elementary.
Elementary.
Why don't you want to go for mediation?
My lord, no, it's a case of the, no, as per their affidavit, my lord. Mediation, or right?
You try.
No,
Why
my lord.
try?
No, my lord, it's, we pray for the provincialization.
Huh?
Provincialization of the service of the petition.
So,
My lord, otherwise,
can it be settled with mediation?
my lord, let the matter come next week then, my lord.
Not next week,
My lord.
after 3 weeks in that case.
My lord.
Mr. A.K. Hussain,
My lord.
Learned Counsel for the petition submits that the petitioner is not willing to refer the matter for mediation. Therefore, prays for listing on matter after 3 weeks. MS so-and-so is present. Yes, element for elementary is present, huh? Standing council is present. Considering above, that this matter will be listed after 4 weeks.
Hello.
Item number 9 becoming unsuccessful. I want to withdraw it.
Mr. K. Kolita, Learned Counsel for the petitioner, submits that writ petition has become in process. Accordingly, writ petition stands closed and disposed of on. Is in process. Huh? Before that.
May I please, Lordship? Item number 27, Lordship.
Yes.
May kindly be taken up after 2 weeks, Lordship.
Why?
Lordship, we need to file reply in this case, Lordship.
You are for?
On behalf of MSN Havelia, Lordship.
Your name, please.
Lordship.
Your
SK
name?
Saha, SK Saha, Lordship.
SK?
Saha.
Saha, Learned Counsel appearing on behalf of MSN Havelia, Learned Counsel petitioner. Praise for is granted 2 weeks time to
Yes,
file
Lord.
affidavit in reply.
Yes, Lordship. Highly obliged, Lordship.
May I please, Lordship? I'd like to make item number 21.
21. Yes.
The matter may be possible for the day.
Why? Why?
Engage counsel not fair.
Huh?
Engage counsel not
You are
fair.
for?
Petitioner.
MS so-and-so, Learned Counsel appearing on behalf of
Ian Sama.
Mr. P.N. Sharma, Learned Counsel by petitioner, submits that Mr. Sharma is indisposed today, therefore prays for listing of matter after 2 weeks. Prays a list after 2 weeks. Huh?
But I like to mention item number 8, Miller.
Hmm.
So it is all pending matter, but thing is that Miller file as a misplaced Miller.
Huh?
So I think adjournment for that day, Miller. By the time Miller, the department also file affidavit, Miller.
Which for the department? Miss, I heard Mr. S. Sinha.
Yes, Miller.
Mr. S. Sinha, Learned Counsel for the petitioner submits that he has misplaced the
Yes.
brief. Therefore, prays for listing of the matter after 3 weeks for reconstruction.
If possible, Miller, date will be fixed, Miller. Otherwise, don't.
Huh?
If possible.
3 weeks, Your Lordship, we'll have to send the affidavit for vetting, then come.
Mr. Devora, Learned State Council
Yes.
to file affidavit in opposition. in the meantime, huh? This after 3 weeks.
Yes.
Lordship, I beg to mention item number 10 and 11. Lordship, kindly adjourn the matter for today
Why?
because he is out of station.
Who?
I am appearing on Mr. N. Upaidhyay.
Hmm?
N. Upaidhyay
Hmm.
appearing.
For?
Lordship, kindly next
On
week
the
any.
prayer of MS so and so appearing, learned counsel appearing on behalf of Mr.
N. Upaidhyay.
Put the learned statement from the irrigation department. Let this matter be listed after 3 weeks. Huh?
of Master
May I please, your lordship. May I beg to mention item number 17, 24, and 25 of the daily list, your lordship. Herein, your lordship, with the consent of other side, your lordship,
Saturday 1/17,
24 and 25 of the daily list, your
you
lordship.
are Mr.
JK Roy on behalf of AM Datta, your lordship.
J.K. Roy, learned counsel appearing on behalf of Mr. A.M. Datta, learned counsel for the list this matter after 2 weeks, 3 weeks, huh? But 24 and 25, it's a further matter.
Yes, your lordship. We've taken the consent of the other side.
Doesn't matter.
On the last occasion, their arguments have been closed, your lordship.
What is the matter?
Whole India matter, your lordship, wherein they were supposed to pay the compensation to the affected villagers, your lordship.
Hmm.
So what I'm praying is, your lordship, let the matter come. We'll close it in 10 minutes, your lordship. My senior will only have to reply on the ground of maintainability, your lordship.
Lordship, any day next week, your lordship. He's in hospital. He's in hospital due to some medical emergency. Any day
That is
next
the
week, your
case,
lordship.
what can we
As
do?
per their convenience, we are.
Lordship, if it's on next week, your lordship, then 12th, your lordship.
Yeah, best.
It is submitted by Mr.
JK Roy on behalf of AM Datta.
J.K. Roy, learned counsel. That leading counsel, Mr. A.M. Datta,
Yes.
is under medical treatment. Therefore, press for listing of the matter after 2 weeks. After a week, Mr. So and so, learned counsel. Huh? Bortakhor, has got a learned counsel for respondent number
24.
7 and 24. Hmm. Raises no objection, however, press for a fixed date list of considering the matter, considering that the matters are further, that this matter be listed on 12th.
Deeply, your lordship.
May it please, your lordship. I beg to mention item 20 to 23, my lord. Records were required, my lord. We are seeking some more time. We have informed the council on the other side.
22, 23.
22, 23.
Yes. On the prayer of Mr. S. I. Bortakhor, learned standing counsel, Forest Department, let this matter be listed after 3 weeks.
After 2 weeks, Lordship,
2
I have
weeks,
heard of it.
so as to enable him to obtain the records. MS
P. Sharma, Lordship.
P. Sharma, learned counsel for the petitioner, is present.
Much obliged.
May it please, your lordship, there's another item 26, my lord.
Hmm.
For the petitioner, I beg to mention, my lord, because council, learned council has, was elevated to the bench, my lord. So we will file a fresh wakalatnama, my lord, for petitioners in 26.
What is the matter here?
Yeah, employees, my lord.
How you are appointed?
We will be furnishing a fresh wakalatnama, my lord.
What a petitioner.
Mr. I. Bortakhor, learned counsel, submits that he has been engaged in this matter recently, for which he would be filing his power within 2 days,
1 week's time maybe.
within a week. Therefore, fresh for listing of the matter after 2 weeks. Praise the Lord, list after 2 weeks.
Respondent number 3, lordship, in this matter.
Mr.
Respondent number 3. W. Rahman on behalf of Mr. A. Sharma.
May I please, your lordship.
Yes.
I beg to mention item 6, it's a joint prayer.
Huh?
It's a joint prayer. Item 16, my lord.
16.
16. Lordship may take this matter up after 2 weeks. I am for the petitioner and he's for the respondent.
the respondent number 1 to 4, your lord.
Mr.
K Pathak.
No, on the prayer of, on the joint prayer of Mr.
K Pathak.
K. Pathak and
And DJ does for us, number one.
DJ Das for respondent number 1.
Sir, there is interim in
Let
item
this
number
matter be
20.
listed after 2 weeks.
2 weeks.
Much obliged.
In item number 20 and 21, there is interim. Kindly interim may continue.
21?
21. I already mentioned the item.
Yes, ready.
Yes.
I heard MS
J. Akhtar.
J. Akhtar, learned counsel for the petitioner, and MS Arborwa, learned standing counsel, education, secondary education. Come on, please, stop. Next matter. This matter is listed for referred to mediation. Mr. Next parent, and agreed to by learn counsel for the petitioner. Third parties let this matter be referred for mediation, referred to mediation, huh? Mr. Miss MS so and so, or Mr. You want any, you have choice mediator? Whom? Anyone? Yes. Just give the name, huh? Is appointed as mediator. Did you give the date? Ardi Majumdar, give the date when? Same order you just did same order. Give the date, huh? Huh? 5th March, huh? Parties to furnish the papers to the learned mediator MS Majumdar, MD RD Majumdar, huh? List the matter after 5th 5/03/2026.
Over.
Yes.
My lord, in this case, both the case issues are same, my lord. The second case, if you take, that will suffice the purpose of the first one, my lord.
No, this is listed for a referral.
My lord, only today's my prayer is this, my lord, my wife is, my lord, suffering from cancer. So certain disputes arises regarding my overstay in the service. So that part is not been regularized, but I have been paid the provisional pension, my lord, at right now. And the GPF, my lord, the total accumulated amount, whatever was there, that was not.
See, today is listed for referral. If you agree, we'll refer it, we'll fix that, give
My lord,
that, fix that.
but whether the purpose will fulfill, you agree? Well, if they are agree, my lord, I have no objection, my lord, because I only to release my money. After that, my lord, matter go
Yes,
for long time.
heard Mr. P. Mahandalan, counsel for the petitioner, and Mr. Diopone, and
For 4, 5, and 6 in item number 4.
is this matter same order? Give the date. 5th March. Mediation 5th March. Who will be the mediator?
Any other people that is there?
PH. Please.
Obliged. Must have.
When 5th of March. You publish the, documents to the mediator.
Well.
Same order.
3 and 4.
This stuff, sir. Huh? No objection. But where is the petition? Where's the petitioner?
Petitioner.
P.K. Majumdar. You just inform after some time. After some time. Just inform him. Why? Where's DK Das? You are for? BTC. Where's the petitioner? Petitioner?
May I please, madam, I'm sorry.
Yes.
My lord, in this case, as your lordship knows, if you remember, these petitioners were having a commercial activity in and around Tongla station, my lord. And they have been serving as, serving to the needs of the passengers, my lord. But since last 50-60 years, on basis of a land license agreement, my lord, which has been denied by the railway authorities now.
No, that has been cancelled,
Yes,
terminated.
but what they have stated in the affidavit is that we do not have the license. But
So
some
some of them you don't have, some of they have,
and
and then
most
those who
of
have
them
been,
have applied.
those
for-
who have been given license, they have been terminated.
Yes, my lord.
What is that? It's not your land.
My lord, it is not in our, they have said that we have applied for transfer.
Whatever.
If
They
that
want
is-
this is the one that they should be used it for Amrit Bharat
Amrit
station.
Bharat station, my lord, and that radius of that project is 200 meters and we are
That-
outside.
It's up to them. It's not your land.
Yes, man.
You are allowed to have some
But-
catering or something like shops or whatever
But
without any authority of law. And license was given for a time being. It has been terminated. Matter ends there.
my lord, kindly hear me out, my lord. As per the affidavit, they have stated that,
Forget about the affidavit. You tell us your case. What right you have?
my lord, they should, as per their affidavit, they have stated that we do not have the license, we have applied for transfer. If that be so, my lord,
Uh-huh.
we are unauthorized occupants, that means.
Huh.
If we are unauthorized occupants, they should proceed against us under the public premises eviction of.
Is it your land? Do you have any right over the land? Except to claim that you have been running this and staying over the, I mean, using the land for last 15-60 years.
Yes, my lord.
50-60 years.
And my lord, regarding the rehabilitation scheme, my lord.
What is the, under what provision?
My lord, there is a case pending before the Honorable Supreme Court, my lord.
We
That
don't
is the
know.
Haldwani's case, my lord.
Huh?
Haldwani's case, my lord, where
Is it related to this case?
there also, my lord,
No, this is related to this case.
no, my lord, those are also unauthorized occupants.
That is something different. Which area? Which state?
Uttarakhand, my lord.
We don't know.
But there, my lord, the Honorable Supreme Court has said that there should be some methodology in achieving the purpose of the requisite land being made available to the railways, coupled with rehabilitation of persons in the area, my lord.
They'll on the facts of
that
that man.
case
What
is-
was the facts there?
Facts are that they have occupied the railway lands on basis of some lease and some unauthorizedly occupants. And my lord, they said some land is in dispute, whether it is of railways or not.
If it is dispute, that's up to them.
So,
This
so
is- there's
that is
no
one aspect, my lord.
There is no dispute here.
Here
it's a
we are
railway-
land license holder, my lord, as we claim,
No, that has been terminated.
terminated, my lord.
So now matter ends there.
My lord, this case is fixed on 24th of February, my lord.
Huh?
This case, my lord, which is pending before the,
That will be different. It's a different on different
this
facts.
is regarding the rehabilitation package, my lord.
That will do.
So they might come up with an,
No, here, what is your, under which law you are claiming rehabilitation?
on basis of equity, my lord.
What is it?
Then
There
some,
will be no equity to the person who is illegal.
my lord, we have been staying there for last 50-60 years.
Does it
That time
matter?
we are not illegal, we have been, we are
That
having a
time since then
symbiotic
you are
relationship.
illegally occupying.
My lord, we are having a symbiotic relationship in that sense, my lord.
Maybe that's over.
I'll leave it to your lordship, my lord. for passing an order.
Huh?
I leave it to your lordship for passing an order, my lord.
Huh?
And only my humble prayer is that some time, at least for 1 month, maybe around till we are evicted. Time frame may be given, my lord.
Let us see your that thing.
I know that page 4, my lord. Order starts from page 3.
This is here. Some of the occupants were claiming that
They were lessees, my lord.
lessee or auction purchasers.
Auction purchaser, as well as there are dispute regarding the land, my lord.
It was a case where, lordship, there was a dispute whether it is a state government land or a railway land. And here it is, lordship, it's a railway land. Admittedly, some licenses were given and that was for temporary occupation, and there was a clause that whenever we need it, they will have to vacate it. Now, the need is that the railway stations are being modernized, the driveways and all those have to be created.
How many people are here?
My lord, here there are 35 petitioners, my lord.
34,
35.
34. Thirty-four. This page 60 is what, about what? You have annexed one order of Supreme Court.
My lord. Well, this is the same case, my lord.
There's no house. They have constructed house or what? Huh?
They have constructed some houses, lordship. But the distinguishing factor between the Supreme Court case and the case here, Lordship, if your Lordship will come to page 63 of the
Yes.
part of that judgment,
Hmm.
living out there in that case,
Hmm.
4365 houses were there
Hmm.
and the land was disputed. It's not the case out here, Lordship.
Well, here the similarity is that they have also lived for decades and we are also living for decades now.
Any, after this order, any
Yes, madam.
action has been initiated?
Last order was passed in the Supreme Court on 10th of my lord, December.
Hmm.
And the matter was fixed on 24/2 for hearing. Well, this is the.
No, any state any action has been initiated by the state
No, my lord. In my
after
case,
the order, after this order,
in that case, my
in
lord.
that case.
My lord, in that case, well, some deliberations were there and as per the last order, it says that let a complete set of paperwork be handed over to so-and-so who is representing the Ministry of Railways and tag along with so-and-so and list on 24 to 26, man. This is the last order, man. It's coming up on.
It's a different, but then still at the same time, the Supreme Court is of the view that some policy has to be taken by the railway and the Union of India and the state of Uttarakhand.
Only note, that was the case where there was a dispute whether the land is railway land
It's okay, but I'm
or state government land. Therefore, the Ministry of Housing and Urban Development is there. That is not the case out here, Lordship.
But that is also a case where the old railway line is being uprooted, where these people are being settled. So that has to be a railway line. That is the point.
What is this additional affidavit? Who has filed the additional affidavit?
Madam, we have filed a reply, madam.
We have filed an additional affidavit, Lordship, bringing on record the lease
Yes.
agreements. And in the lease agreement, Lordship, there is a specific clause which says,
Page.
I refer to my affidavit, Lordship.
Additional affidavit.
It starts from page 71, madam.
65. You have filed the additional affidavit.
Madam, we have filed a additional affidavit incorporating the license agreements, madam. It
Additional,
starts from page 71, madam.
seen it, where it is.
The license for temporary occupation of land.
Where occupation of land,
Yes, page 71, my lord, annexure 5.
license for temporary occupation, yes. In which year this is?
This was in 2015, madam.
April 2012 to 2016,
Yes.
it's over.
The relevant clause will be clause 7 of that. But perhaps,
75.
second copy, there is no 79 page. There is no 70.
There is no 7, it's from 4 to directly 12.
It is not there. The relevant clause, I have checked up. It should have been in page 72. It should have been in page 79. Only that page having that relevant clause is not there. 79 is also not there. No,
Yes.
not there.
Well, the same copy,
Same copy.
well, then my same.
79.
According to you, the relevant clause will be 7. And you have not annexed the,
Well,
Clause
we have
7.
annexed, perhaps in my copy it is there.
it's not here.
Madam.
Have you annexed it?
I have quoted it in my affidavit, Lordship. Your Lordship will come to page 115.
Yes.
Page 115.
Hmm.
In relation to paragraph 11. Clause 5, that the government only agrees to give temporary occupation of the land for the licensee is liable to have this license cancelled at any time upon such notice as is mentioned in clause 20. Clause 20 notice has been given to him. 7, it is distinctly understood by the licensee that the government will retain the full legal title, ownership, right of access, inspection and control over the use and disposal of the land hereby temporarily licensed to the licensee. And that the licensee will only have physical occupation of the land subject to the above mentioned rights of the government and to the overriding liability of quitting and restoring even the physical occupation at the will and pleasure of the government.
Yes. You are trying to base your argument on this license.
Yes, my lord.
There's a provision and they have acted as per the, the clauses of the agreement, license,
Yes, my lord.
nothing.
Well, my second line of argument will be this license, my lord. We have, some of us have also applied for transfer in our name, my lord. My lord, that was pending and being so, my lord.
That license has been already, they want the land for development of this
Yes, ma'am.
railway station. So, yes, BTC. You are not, this is a property of railway. Heard, mister?
M. Khatoniar, madam.
Huh?
M. Khatoniar.
M. Katania, the counsel for the petitioners. And also heard Mr. R.K.D. Chaudhary, learned DS.
I've got 2, 3 and 4 also.
Respondent 2, 3 and 2, 3 and 4. And BTC, Mr. M.K. Das, standing counsel BTC and
Oh, sorry, let's say I'm for 2 and 4.
2 and 4, huh? 3. DP Bora. D Bora, State Council, Standing Council. Dismissed.
Obliged.
I'll pass the order. That's it. All right.
Also obliged.
Chamber. Ah,
Wait, his lordship. Lordship, I tried contacting Mr. P.K. Mojumdar, advocate for the petitioner. Lordship, he said that he's no longer counsel in this matter, Lordship. Lordship, the matter may be fixed some other day, Lordship. If some new counsel takes up the matter.
then you write, none appears for the petitioner. Ms. Arborwa, and state councillor, who has been requested to inform Mr. P.K. Majumdar, which is shown as the land counsel for the petitioner. Come on, inform that Mr. Majumdar, P.K. Majumdar has stated that he's no longer is no longer the counsel of the petitioner. It's considered I would let this matter be listed after 2 weeks. We'll see after 2 weeks.
We have no difficulty in for mediation, Lordship.
But then this,
Petitioner.
it cannot be, you just simply cannot say that I mean, where is Mr. Majumdar?
I have taken the phone number from the file from Lordship. I've tried contacting him. He said he's not in court right now. He's at home, Lordship. He's some difficulty today. There's some personal difficulty and he's no longer a counsel in this matter.
But you inform that you just cannot do like this unless you issue a notice to the petitioner. We're fixing, listing it after 2 weeks. Tell him that the court wants to know what action, I mean, what steps you have taken if you are no longer a counsel. You just inform.
Court, Lordship. Duty of the counsel.
You just inform him.
Lordship, I'll inform.
12 Lordship. Regarding the appointment of Kapoor, he is not eligible as because that the age criteria those were given. Earlier it was 35, my lord, as per my notification, my lord, it was reduced to 30 years.
Lordship may take up this matter next week, Lordship, any date, Lordship. I will
Why?
obtain instruction, Lordship.
What is your case?
Because of the stay order, Lordship, they are enjoining the stay order. My lord, that process has been stalled, Lordship.
Why you have not filed affidavit?
After the motion, Lordship. Order was passed on Lordship 25/7/2018. This is the notification, Lordship. Taken to cover him. itu কিন্তু আমার একদম হয়ে যাবে এই পাবো এই পাবো এই পাবো 30 years. Not 30 years. 30 years.
What is the advertisement?
Advertisement is page Lordship 20 Lordship. Earlier it was balloted 20.
Huh? They are relying that in earlier advertisement, there was no age limit. Even if it was there, it is start from, I mean, 21 years to 40 years in some of the advertisement.
Now, my lord, this, my lord, after the new notification, my lord, The SSLC, they have to pass the SSLC exam.
What is your qualification? What is your age?
Thirty, at
Huh?
the time of filing this writ petition, Lordship, 30.
The petitioner, in this case, Lordship, his age is 30, he is eligible now. So at Lordship can,
And what is
get
your,
the stable
what is your
level.
qualification?
HSLC pass, Lordship.
He is a
But you are,
At-
you are 31 years.
30,
When this petition was filed.
30, sir, 30, Lordship.
Now he is eligible.
he is eligible.
So this was JJ stay.
Yes, Lordship.
Earlier it was Lordship, it was 35 years. Now, it has been, that
In
notification I
the,
have.
by
given.
lapse of time. Where is that order of stay?
Order dated,
25,
Copy
7,
that there. In the
2018.
entry advertisement as sell remains as till the next directory is direct reflecting name of land estate. Huh? So we'll dispose it of.
Lordship, there's a take matter.
We'll direct them to go ahead with the advertisement, and by the time we'll make an observation that although you are not eligible as per the advertisement, there is no ground for challenge it, but then by flux of time, you become, the petitioner has become eligible. In the event other than the age, I mean, in the event you are found to be eligible, consider as per the advertisement.
Notification, Lordship.
Item number 13, he will not be eligible.
Huh?
Item number 13, he will not be eligible.
Yes.
Now 13.
No, one by one, 12 we are disposing now.
Lordship 12.
Take up this matter to Lordship. I will call my senior.
Nothing, nothing. This is the issue only. Who will argue the matter?
I Soikia, Lordship, my senior.
Right. So what is to be done? What to do?
You can dispose it of.
Well, this is of Lordship, only that.
No, where you by this time, you are eligible now. So you'll be considered as per the advertisement. We are not interfering with the advertisement, right? Heard, Mr.
K. Kashyap.
K. Kashyap, learned counsel for the petition, and also heard Mr.
Respond number 1, Revenue
J-
Department.
J. Hendrik, learned standing counsel for Revenue Department, learned standing counsel Revenue Department, for respond number 1, and Mr. D. Bora, learned state counsel for respond 2 and 3. Yes. Challenge made, next para, challenge made in this writ petition is to the advertisement dated 01/06/2018 issued by the Deputy Commissioner Barpeta, whereby applications were invited from the local people to fill up the vacant post of 07 number charge Gabura of Baguribari Moja under Senga Revenue Circle. In respect of the, as regards the clause 2, which provides the minimum qualification to the effect that the age of the applicant shall be 35 years or above as on 01/01/2018 and shall be HSLC pass equivalent to the same from the Government of Assam recognized board or institution. List of. Next paragraph. The petitioner claims that he has passed high school leaving certificate examination in the year 2005. And his date of birth is 30/06/1988. list of the Deputy Commissioner Borpeta by advertisement dated 01/06/2018 invited an application from the local people to fill up the vacant post of Gaubura, 07 number charge Gaubura of Baguribari Moja under Chenga Revenue Circle. The advertisement inter alia provides the minimum qualification to the effect that the age of the applicant shall be 35 years or above as on 01/01/2018. Next paragraph. It is the contention of the petitioner that in earlier advertisement for appointment of Gabura, there is no prescription of age, or if subsequent earlier application provides, even if it provides, it has been provided that the applicants, the age of the applicant shall be 21 years to 40 years. The raising of the bar raising of the age bar to 35 years and above is arbitrary, as there's no rationale behind raising of the raising of the age bar by departing from the earlier practice for appointment of Gaburas. List of it is further contended that that had the age of the applicant is not fixed to be 35 years or above, the petitioner would have been eligible in all other respect, as he has attained the age of 31 years.
30 years.
30 years. Wherein in earlier advertisement no such fixation of age to be 35 years was even resorted to. List of next para. This writ petition. No. It is submitted by the Land Council to the parties that
Notification
by a flux of time, the petitioner has already attained the age of 35 years and above.
Earlier he was, it was my lord at 35 years. Now, my lord, as per that notification 21, it's reduced, my lord, amended, my lord, that clause 162 it is about 30 years now.
30 years.
30.
Again, by this.
Earlier it was 35, now it is amended as a 30 years. Lordship, paragraph number 3, Lordship. CL number 3.
And retirement age is Lordship Valora 65 years.
Earlier it was not there.
So in 2021 only it has been amended, making it 30 years.
Initially, my lord, 2018, this notification was published. It was, my lord, 35 years. In person to that notification, my lord, this advertise was made. Now it has been, my lord, after this notification, it was amended as 30 years. Earlier, my lord, that retirement age was not there. Or in person to the, my lord,
We're not concerned about retirement age now, right? Yeah.
that's why, my lord, this amendment has been made.
So retirement age, we are not concerned in
Lord.
this petition. Then you, last paragraph, delete. Okay? No, you said. Mr. J. Hendick, by placing the notification dated 26/08/2021 issued by the Commissioner and Secretary to the Government of Assam, Revenue and DM Department, submits that by after the advertisement, impugn advertisement dated 21/01/06/2018 issued by the Deputy Commissioner Borpeta, Borpeta. The state has amended the executive instructions, particularly executive instruction by making the reducing the requirement of 35 years of age for appointment of Gabura to 30 years. List of. Therefore, he submits that the authority will issue a fresh advertisement in terms of the new in terms of the
Amended.
amended in terms they said notification wherein the age of 35 years should be brought down to 30 years. Huh? Next, consider the submissions of learned counsel for the parties, and also there is the materials, particularly the notification dated 26/08/2021 issued by the Commissioner and Secretary to the Government of Assam, Revenue and DM Department. Next paragraph. The challenge to the advertisement that impugn advertisement that is 01/06/2018 is essentially with regard to the requirement of 35 years of age, 35 years or above, 35 years of age or above in respect of for appointment of Gambura in terms of the earlier, in terms of the executive orders, executive instructions issued by the state government, list of the petitioner was 30 years of age when this writ petition was filed, challenging the said impugn advertisement having other eligibility, having other eligibility for appointment to the Gabura. Please stop. Next para. This court, when the notice was, while issuing the notice on 25/7/2018, suspended the impugn advertisement dated 08/06/2018, for which perhaps there could not be, there might not have been any selection process been taken pursuant to the advertisement, said in impugn advertisement for filling up the post of Gabura of 07 number charge, Baguribari Moja and the Chenga revenue circle. Huh? Still. As noted above, the state authority respondents issued an notification amending the executive instruction by dated 26/08/2021. Particularly to the instruction number 162, clause 1 and subclause 1, whereby the requirement of 35 years of age for appointment of Gabura has been reduced to 30 years, which is in vogue, huh? This stuff. Does the authority, the deputy commissioner, is required to issue this advertisement inviting application for filling up the vacant post of 07 number charge Gabura of Baguribari Moja under Chenga revenue circle, in terms of the amended, in terms of the notification dated 26/08/2021. Next paragraph. Practically, no. In essence, the writ petition appears to be infructuous in view of the amendment of the executive instruction, whereby the requirement of 35 years of age for appointment of Gabura has been reduced to 30 years. However, as agreed to by the learned counsel for the parties, no, not however, huh? Please, however, it would be appropriate. It is appropriate to dispose of this writ petition, allowing the Deputy Commissioner Barpeta to issue a fresh advertisement for filling up of the post of Gabura, post of 07 number charge Gabura of Bagubari, huh? In terms of the notification dated 26/08/2021. particularly with regard to the, as regards the, as of the applicant. List of. Next slide. Having considered above and having considered the having considered that the requirement of the applicant to be 35 years for appointment of Gaubura having been reduced to 30 years by the notification dated by notification date 26/08/2021, and as agreed to by the learned counsel for the parties, I deem it appropriate to close this writ petition with a direction to the Deputy Commissioner Barpeta to issue a fresh advertisement in accordance with the notification dated 26/08/2021. For filling of the vacant post of 07 numbered charge Gaubura of so and so, within a period of 1 month from today. 1 month from today. List of it is ordered accordingly. Writ petition is just disposed of. That's all.
Similar matter. Similar matter.
He is not eligible.
Is
His age was 20 years at the time of filing this petition. Lordship.
no, it's not eligible.
Perhaps.
So what is your ground to challenge? Where is the advertisement?
Same as that, I think.
20.
Same.
Page number 20.
You are 20 years.
At the time.
Then almost same thing.
Same charge number, same district, same.
Here also will say that to issue a press advertisement. However, will say that the petitioner could not make out any case for interference. We'll add that. Petitioner failed to make out any case for interference as the only ground is that in earlier advertisement there is no prescription of or raising the age limit up to 35 years. Therefore, no interference is called for. However, to issue press advertisement, right? That answer. This one. One paragraph would add there. Yes.
For pensionary benefits, but as per our affidavit, Lordship, our stand is that the minimum requirement of 10 years, which is required for getting pension under CCS pension rule, at the time of, because he had discharged on the ground of unsuitability, the petitioner had not completed that. He had only 9 years, 2 months of service.
Requirement is?
10 years, minimum 10 years.
Yes. Then?
He is not eligible for pension. And so far the discharge order, this is of 2004. And now in the year 2018, that has been challenged.
Non appears for the petition on call. MS B. Sharma, learned CJ seat for the respondent is present. Dismissed for it appears that the petitioner is no longer interested to pursue this matter. Accordingly, the petition is then dismissed. The petition is dismissed for non-prosecution.
Sure.
May I please, Your Lordship?
Yes.
Matter is pertaining to compassionate appointment, Lordship. Compassionate appointment, Lordship.
Compassionate appointment.
Lordship.
What's there? What remains there now?
Lordship, judgment rendered by our honorable court, Lordship. According to this is a judgment, Lordship.
What judgment?
Lordship, according to this judgment, all the compassionate cases, Lordship, which is pending this before this honorable court, Lordship. This is the
Show him.
judgment matter. Lordship, according to as
My lord, those things are all over, my lord.
Lordship, we came to know this little later, Lordship, about this
And
judgment.
in that case, my lord, they had to challenge this. Those only challenge the OM, my lord, of
Ah.
2024 regarding those cases. Here, they did not challenge the OM.
Where you
Only-
have done away all the compassionate scheme,
That's it.
all the scheme and policy you have done away. And you will be providing in place of compassionate appointment, compassionate
Family match.
family pension.
Those who have died,
These are the cases where
OM of
OM that
24.
2024 has been put to challenge. In that context only, those who have filed as and when. I
Here,
think you have missed the boat.
Lordship,
You have missed the train.
and anyway, this is, my lord, already considered in 2013, DLT
Ah.
meeting considered their cases. So nothing left.
You have filed the affidavit. Have you filed the affidavit?
Yes, my lord.
this is
Saying what? Respond number 4.
In Page number 20, running page 21, my lord. Para 4.
The proposal of Jadab Tamuli pertaining to Director of Employment Craftsman was placed in district level meeting held on, but could not be recommended due to lack of vacancy. And it was the same will be placed in the next DLC meeting subject to agreement, but the same was not seen to be placed in the subsequent. So
So considered, my lord.
what considered? Mr. Dad,
My lord, this is called consideration, my lord. My lord, if you go by Achutaranjan Das,
see, you have said that in your affidavit, you said you have considered, but due to lack of vacancy, that will be considered on the next DLC. Then you said, but the same what was not seem to be placed in the subsequent DLC. Why you have not placed it?
my lord, now, I could come to, then, Devabrat Tiwari. My lord, the immediacy is gone. That is,
See, when you have not considered and let the time to pass on, what's the question of saying and after many years you said immediacy has gone. How do you expect that?
what we said here. Initially, there was the consideration, no vacancy. Means what? We have given a consideration. We kept it for further consideration, my lord. One consideration is given. There was no vacancy.
Sir, I understand. Try to be a little, I mean,
My lord, the honorable.
try to be a little polite.
No.
See, facts remains that you have considered and you have not rejected it, in fact. You have said there's no vacancy, therefore we'll consider in the next DLC. Then you said that it has not been considered on the next DLC. You could have rejected on first DLC.
Sometime, my lord, district level, they keep it, my lord.
Say
And-
so, na, you
Yes, sometime, my lord,
admit your, I mean,
my lord, on compassion ground, my lord, they keep it.
admit your fault also.
We will try to accommodate, but what happens, my lord, sometime it doesn't arise.
If we go by your affidavit, we'll direct you to reconsider. taking into account that it was of 2013.
My lord, now there is no DLC, no SLC. Who will consider, my lord?
See, that the approach has to be changed, Mr. Dar.
My lord, that is what.
You did not consider, you did not reject it that he is entitled or not. You simply said there's no vacancy. Now, if there's no vacancy, you said you will be considering. You have not considered and allowed the time to pass on. Then you said immediacy is gone.
My lord,
Immediacy is why Supreme Court has so because suppose you were, I mean, you ought to have claimed 10 years or 20 years back. Now suddenly you come to the court that I should be, I mean,
Supreme Court in Devabrata Tiwari has said
Hmm.
that the fault may be of either of the parties, but still it cannot be considered.
I'm just trying to interact, I mean, impress upon Mr. Dhar. He's not convinced to me. I could not convince him. Nothing doing. You have missed the bus.
I leave
What
it
to
your
do?
lordship.
Huh?
I leave it to your lordship.
What Libby, you think about it? It's a compulsory appointment. I'm not interested in disposing the matter also. Think about it. At best, we'll be dismissing your writ petition.
Now the problem is that, my lord, there is no, we have already done away with one time that measure, my lord, when there was, now there is no SLC, no DLC. Everything has been with an OM, my lord. It has all gone. If they want to bring in
Because
this,
OM is still there.
Lordship.
OM, this court has not interfered with the OM. Although there is lots of, I mean, so many petitioners have challenged that OM.
OM is still
Without
there.
interfering, this court has, we have directed them to consider those who have applied and before or after something like that, which you are, I think, relying.
Lordship.
That we cannot do in your case because you have not challenged that order. And you know that it was 2018, you have filed a writ petition 2018
Lordship.
and that OM has issued in 2024. You should have been little vigilant also.
After the
You
OM,
withdraw will give you a liberty to file afresh. You may challenge that. I don't want whether that will be again maintainable or not. It's very risky. Instead of dismissing it,
Lordship.
will you withdraw it? Will give you a liberty. Whatever you want to do it, whether that will be again maintainable or not, we don't know. But if you want to have that same order, you have to challenge that order.
was without that order, my lord. Following this
Because
order,
all the these policies and schemes is already done away. And the court has not, that was put to challenge that OM, but it has not been interfered with as on today, right?
and thereafter, my lord, we have gone further. We have come with SOP,
Huh.
and that also we have in a IA we have brought before the honorable court, and we have done away. All these applications, those are pending. We have considered, and now we are passing, my lord, this orders, speaking orders, communicating.
And MS
K. Bapujari on.
Huh?
K. Bapujari.
learned counsel for the petition, who submits that she may be allowed to withdraw this writ petition with a liberty to file afresh if so advised. A prayer for withdrawal is accepted. Mr. So-and-so
My lord.
are the learned
My lord.
addition senior government advocate. And Mr. B. SP Das,
Number 3, madam.
standing counsel.
Standing
counsel?
3,
Standing counsel?
or Directorate of Employment and Customer Training.
You just take.
Number 3.
Yes, and learned state council correspondent are present, huh? Then you write, prayer for withdrawal is accepted. Accordingly, writ precedence clause as withdrawn with a liberty as spread for. You think about it, otherwise it will be no use.
Obliged.
May I please, Lordship?
Yes,
Lordship, the matter relates to compassionate appointment. Lordship,
again,
what happens, recently a development took place in this matter, balance of service. I mean, that issue has been, in this matter. So an appeal has been decided by this division, honorable division bench of this honorable court, Lordship. And in the meantime, Lordship, actually, this is a 2018 matter and some inadvertent mistake took place on our part, Lordship. The file has been misplaced. So let the matter take up after a week, Lordship. Let the matter be taken up after a week or two.
no, have you not seen just now? Nothing remains,
Lordship,
nothing remains.
Lordship.
Withdraw, will give you a liberty to file a fresh, challenging that OM, if you wish.
Lordship, in this,
Same series, same thing,
Lordship,
huh?
OM has to be there, haven't challenged the OM.
Lordship,
Same thing.
Lordship.
Were you there?
Yes, Lordship.
Just a minute
I mean,
ago,
I was just.
just a second ago. Same order. Heard, mister?
Lordship,
Nothing. We have deliberated on this. See, it's a compassionate appointment.
yes, Lordship.
We do have a compassionate.
But
But then,
Lordship, then allow
in
me
view of
5
the
minutes time.
developments, nothing. Sir, nothing.
Let me take it,
This is decided by whom?
Lordship.
Your case has been considered by DLC or SLC,
Lordship, actually,
or there was no consideration at all.
file was not with us, Lordship. Lordship, allow us 5 minutes to take the instruction, Lordship.
Same order. Same order.
Lordship, kindly take up the
Five-
after some time, Lordship.
5 minutes.
AR Bhuya will apprise you,
5 minutes.
Lordship.
5 minutes.
Lordship,
Yes, 5 minutes. After some time. We cannot discriminate.
Lordship,
Same thing.
Lordship.
Solo Suru Goro.
My lord, this is also,
Compassionate.
yeah, but against the Union of India. I take your lordship, their affidavit, page 38.
Ah,
Their affidavit, page 38. Annexure 3. Wherein it has been asked me last, my lord, in 22, asked me, it is intimated as per the direction of the headquarter. All the requisite documents should be sent to the older the 21. Therefore, you are requested to submit the following documents. Accordingly, my lord, all the documents I have submitted.
then
Thereafter, nothing has been done. That's why I'm before your lordship.
where it is?
Page 38 of their affidavit.
38.
38. That is the last communication.
As per the direction of higher, all the requisite documents should not be older than 2021.
22.
Therefore,
Two
you
good-
request submit the following by 10 should not be older than 2021.
That is earlier one. That page 38, my lord, your lordship.
I'm
It is
reading
dated
page
2nd
annexure
June
3,
22.
page 38.
Yes.
You read whole thing.
My lord, I take.
It
yes,
is intimated.
Yes.
Yes, you read whole
It is page 37, my lord.
38.
38, it is intimated as per the direction of the higher headquarter. All the requisite documents should not be older than 21.
Huh.
Therefore, you are requested to submit the following documents by 10 June 22 for our further action.
Yes.
So according to all the A, B, C, D, E, F, G, H I have sent.
These are all not older than the 2021.
Yes, I have given.
From where you show us the documents that these are not older than 2021.
It's perhaps confusion.
Yeah.
I'll just clear. Lordship, if your lordship will see the repetition, it is of 2018.
Yes.
2018.
Yes.
This document is of 2022. That is my document.
Yes.
Now, the applicant's father died in the year 2010. And the applicant's petitioner's candidature was considered from 2000 lordship for 4 years, 2010 to 2014. There were no vacancies because it could not be accommodated. However, now they have been asked by the authorities to submit further papers as per page 38. Now the question remains here is, if at all the documents are submitted, then that will again have to be considered in that 5%. And Lordship will also consider where a compassionate appointment, the very scheme. Death in 2010, now we are in 2016.
26. 26. 2026.
26.
We are in,
Yes.
death in 2010, so 16 years. Whether consideration now,
In 2022, you have asked for the documents.
Yes.
If they have furnished it, you consider it. But
Yes, otherwise reject it.
because for me, I do not know whether any action has been taken by the petitioner on this. If he gives a statement that it has been submitted,
Then
Lord-
my friend take time also.
no, I will not take time. Lordship will pass an order closing the petition that will be considered as per law.
yes.
As per law on the or letter
You
dated
show
second
us-
June of 20.
See, you are required to submit the documents, these documents, which shall not be older than 2021.
Yes,
Have you done
I've signed
so?
it, madam.
Have you done so?
Yes.
If he has.
I'm
You
sure.
can
Show
close
us.
it, you close it, the matter.
Show
I've-
us,
Your lordship may close the matter.
sir, show us the documents which you have submitted. Again, this will be unnecessary, the futile exercise will direct them to consider, and they found that you have not submitted the documents. Again, this will be rejected. Why, see, normally we don't, law doesn't permit to issue a futile writ or direction. I am not disbelieving you, Mr. Vishwas, but you'll have to show something that as per this, because this affidavit is filed after your writ petition.
Yes.
Then you have you have a right to file affidavit that, see, look at, we have already submitted.
My lord, may I submit one line? Your lordship had disposed it with the direction to intimate me the fate of this latest communication.
First, you have to satisfy
When
that
he
you
has
have
to respond,
submitted.
only then the fate will come.
Yes.
My lord, to my
Are you
information.
getting me? Suppose, though we are not disbelieving you, but then suppose in the case you have not submitted, if you direct them to consider, will it not be a futile?
But my lord, to my affirmation, my lord, I mentioned that all the documents forwarded to this case, the petition headquarters, chief engineer,
Where?
page para 7.
Para 7 in the writ petition.
Yes.
How can this be? You have filed a writ petition, you have been directed in 2022 to submit the documents,
That
which
is the
should be
request,
not
my lord,
older than
because
2021.
all these documents we have submitted earlier, that's why they have intimated us. We have submitted, without all these documents, they cannot forward our.
Please read page 38 again.
Yes, I have read.
Huh?
It is intimated that as per the direction of the higher headquarter, all the requisite documents should not be older than 21.
Next slide.
Have you submitted that?
Therefore, you are requested to submit the following documents by 10th June 22.
Huh?
My lord, it was a 22 letter, my lord. Thereafter, my client has sent it. Of course, I have not brought it into record
The way you are trying to...
by filing
refer to-
an affidavit
Hmm.
that I have not brought. It indicates that definitely they have received some communication from me. Otherwise, why they will take up the matter in 22 again, asking me you file this further documents.
Insofar as Lordship, the central scheme is concerned, Lordship, there is no time limit for consideration. That is why.
If they reject it, my lord. But matter is pending. That's why we are with the hope that someday good news may come. Otherwise, I am surviving with the meager pension that received by my mother.
Who are you?
I am the son.
Doctor,
I am the daughter, my lord. Of course, I do not know whether I got married or not, my lord, because it is a matter of 2018. No communication with my client.
better to take instruction or what to do. Will direct you to consider taking into.
If submitted, yes. Yes,
Add those two words.
close it, my lord.
Okay.
If submitted.
Heard Mr. SC Biswas Learned Counsel for the petitioner, and also heard Mr. RKD Chaudhary Learned DSGI for all the respondents. By next para, filing this writ petition, the petitioner has sought for a direction to consider for appointment on compassionate ground against any suitable vacancy on account of the death of her father,
Yes, her father.
late,
Died on 26/6/2008, my lord.
father, name of the father,
Father's name is my lord, just 1 second. Madhuram Boro.
where do you have mentioned?
The cause title lordship will see page 3.
Father, huh?
Yes, page 3,
Late Madhuram Bora,
page 3, page 2, you know.
who died in harness, was working as what is this?
Chomin Chowkidar,
Huh?
Chowkidar, CBB.
Working at Chowkidar
Yes, you're right, CHOW, my lord.
within bracket CVB, huh? Page 5.
Under
At
MES
Misa
Misamari.
Mari, who had died in harness on 26/06/2008. This stuff. Next para, the petitioner being the unmarried daughter. She might have.
Maybe. That's right. If that, she will not get. Of course, there is no bar for appointment.
Seeing the.
If being married
the
also, madam.
Eldest and the unmarried daughter of the deceased employee, of her deceased father had applied for appointment on compulsory ground on by dated 24/11/2008, along with all the required documents. What is the what is the policy? Is there any policy? Is there any policy?
He has not.
He has not annexed the policy also.
We cannot collect all these things, my lord. Illiterate person, my lord.
No, he has annexed that page. I'm sorry, he has not annexed it.
On list of on such application. The case of the petitioner was placed before the selection board of the committee for compulsory appointment, and it was
Copy of my affidavit, it's there.
just wait, huh? And was listed in the combined list of compulsory appointment for the year 2013, 2014. And the same was forwarded on 21/09/2016. To the competent authority. Next para. The thereafter, next para, huh? The Commander Works Engineer, Military Engineering Services, Tezpur, Respondent 6 hearing. By letter dated 22/03/2018. Again forwarded the case of the petitioner to the headquarter, Chief Engineer, Siliguri Zone. Requesting for initiation of action for appointment of the petitioner on compassionate ground. However, was returned back, directing the concerned authority to obtain information from other zones. It is next paragraph. It is the contention of the petitioner that despite several correspondences, the case of the petitioner, the petitioner could not be appointed on compassionate ground without any justification which led to which is the petitioner which resulted in acute financial hardship to maintain her and maintain the family. List of. Therefore, the respondent authorities may be directed to consider the petitioner for appointment on compassionate ground on any suitable post. List of. What is your stand? We'll just go this that you have asked for documents.
Now we have, her application was under the previous scheme. Now there is a clarification dated 7th March 2019 that we can again consider it.
Okay.
So in view of that, we have issued him the letter.
Okay.
Now, if he has submitted the documents, then.
Yes.
Mr.
Very true, very true.
Mr. Arkady Chaudhary, Learners Deputy DAJ, for the respondents. Fairly submits that, not fairly, submits that the case of the petition was considered in the under the earlier scheme 2010 to 2014 due to non-availability of vacancy. The case of the petitioner could not be due to non-availability of vacancy, the petitioner could not be appointed.
And thereafter by Annexure 2, Lordship, a clarification was received.
Yes.
That is at page 37 of my affidavit.
Yes, yes.
In view of that, we have again asked for the documents.
It's okay. Thereafter, on the, what is, this is clarification,
This is a clarification, Lordship.
saying what?
It was rejected due to lack of merit not found. I'll just read out the second paragraph. A clarification was sought from DOPT by so and so, white letter number so and so, and the same has been clarified by DOPT by their OM dated 30 April 2015, that in view of the above, all service headquarters, lower formations are requested to follow the DOPT's above guidelines in letter and spirit. They may not reject any application for compassionate ground simply on the ground that it had already been considered thrice, unless it was rejected due to lack of merit, not found suitable under the criteria for compassionate appointment. If the compassionate appointment could not be granted due to non-availability of vacancies at that time, any fresh applications received now should be reconsidered after adjusting his precarious conditions on the basis of the family's latest financial economic condition, number of dependents of the family, as on date, latest marital status of the dependents, etc. Now, earlier it was rejected on the basis of lordship, there were no vacancies. Now it has to be considered on the basis of merits.
Okay. We'll say, he submits that in view of the decision by letter dated 07/03/2019 by the authorities, whereby the cases of compulsory appointment, whereby it has been decided that the cases of compulsory appointment should not be, may not be rejected simply on the ground that it had already been considered twice unless it was rejected due to lack of merit or not found suitable under the criteria for compulsory appointment, comma, all the applicants were directed to furnish the documents, right? Furnish the documents directed all the applicants, the competent authority, the authorities by letter dated 02/06/2022 has directed the requisite documents which should not be older than 2021. Mr. He fairly submits that if the petitioner has submitted all the requisite documents in terms of the communication that is 02/06/2022, comma, the case of the petitioner shall be considered in accordance
7th March.
in accordance with the relevant applicable policy and the circular or the communication and the communication that is 07/06/03/2019. That's all, Mr. Mr. S.C. Biswas learned counsel by the petitioner submits that he has been informed. Submits that S.C. Biswas learned counsel by the petitioner has made a categorical statement that the petitioner has submitted all the requisite documents as per the communication that is 02/06/2022. Therefore, the respondent authorities may be directed to consider the case of the petitioner in terms of the applicable policy of the scheme and the communication that is 07/03/2019. Mr. Next paragraph. Consider the submissions of land council for the parties. Next paragraph.
10th February.
10/3.
No, February. 15th February. Monday.
The case of the petitioner claiming for the case of the petitioner claiming for appointment on compassionate ground on the account of the date of his father, on account of the death of his father, who had died in harness while working as chowkidar under the respondents has been considered by the authorities initially in the year 2010 to 2014. However,
Paragraph 6 of my.
however, due to non-availability of vacancy, she could not be appointed on compassionate ground in terms of the applicable scheme for appointment of on compassionate ground. Please stop, huh? Next paragraph. Well, no, Mr. During the pendency of the writ petition, present petition by communication dated 07/03/2019, the respondent authorities appears to have decided that any application for compassionate appointment shall not be rejected simply on the ground that it had already been considered thrice unless it was rejected due to lack of merit or not found suitable under the criteria for compassionate appointment. List of, if the compassionate appointment could not be granted due to non-availability of vacancies at the relevant point of time, any fresh application received should be reconsidered after adjudging his or her pecuniary conditions, pecuniary, huh? PENURIOUS condition on the basis of the family's latest financial oblique economic condition, etc. Economic condition, number of dependents of the family as on date, latest marital status of the dependents, etc. in the light of the existing guidelines. List of pursuant to by communication dated 02/06/2022, the respondent authorities has directed and informed and directed and communication informed and directed the petitioner to submit all the required documents which should not be older than 2021. List of although nothing has been brought on record to show that no, you just in person thereto the learned counsel by the petitioner has made a statement that the petitioner has submitted all the required documents as sought for by the respondents by its communication dated 02/06/2022, although nothing has been brought on record to show that the required documents had been submitted. In actuality, it has been submitted or not. We'll have to show that.
Yes,
say
yes.
Mr.
Very good,
However,
yeah.
as fairly submitted by Mr. Chaudhary, Learned DJ, if the petitioner has submitted submitted all the requisite documents in terms of the, as per the communication that is 02/06/2022, the authorities would be duty bound to consider the case of the petitioner in terms of the applicable policy of the respondents. That's having considered the submissions of learned counsel for the parties and considering the petitioner has stated to have submitted all the requisite documents as sought for by the respondent authorities. I deem it appropriate to dispose of this writ petition with a direction to consider the case of the petitioner in accordance with law. Accordance with law, we'll just say accordingly. It is directed that the case of the petitioner be it is directed to the respondent authorities to consider the case of the petitioner if the petitioner has submitted all the requisite documents as sought for by a communication that is 06/2022 in accordance with the existing applicable policy of the we'll say respondents. Mr. The consideration is directed here in above shall be within a period of 3 months.
Lordship.
3 months from today.
Okay, Lordship.
3 months from today. I'll be signing it in the evening. 3 months from today. Writ petition stands disposed of in terms above. 18. Yes.
Lord, I'm sorry.
Before
my
you
lord.
start, Mr. Boya,
My lord.
just what is the last item? Item 16? 15. Same.
Lord,
2018
my lord,
probation appointment.
my lord,
In view of the subsequent developments, issuance of all these things,
my lord.
we have allowed, in fact, this court ought not to have been
My lord.
finding no way out, suggested to withdraw the writ petition with a liberty to file afresh.
My lord,
Because now
yes, my lord.
that OM 2024, which has done away all this scheme,
Yes, my lord.
all right,
Yes,
was put to challenge, and there's no interference by this court.
no,
Rather, a direction was issued
my lord,
to
direction,
consider.
my lord.
So for that to provide you a similar relief
My
in
lord.
case if you claim
My lord,
in the writ petitions,
my lord.
as that of those writ petitions, then only you will have to challenge them
My
so
lord.
that we can examine whether your similar relief can be
Or, my lord,
provided to you.
my this writ petitions, my lord, can be disposed of relying on the single judge as well as the division bench order has already, my lord, interfered with this policy of 3 years that remaining period is required. my lord.
Difficult.
Now, my lord,
We'll give you you file a fresh petition, we'll consider it, challenging that, because that has not been interfered with as on today.
the new OM, my lord.
Yeah,
No,
because that has been done away.
yes, yes.
All
the-
your claim under in this writ petition has been done away, all this policy.
But, my lord, it will remain, my lord. The rejection by the DLC will be there, my lord.
No, it's okay.
Now that policy is not there.
Ah,
All the YMs are gone.
heard Mr. A.R. Buya, learned counsel for the petitioner, who not heard, Mr. A.R. Buya, learned counsel for the petitioner, fairly submits that he may be allowed to withdraw this writ petition with a liberty to file in view of the subsequent developments as regard the scheme of the policy for appointment on compassionate ground.
Compassionate ground.
Mr. Arthur, learned additional senior government advocate for the respondent is present. Prayer for withdrawal is accepted. Accordingly, writ petition stands closed as withdrawn with a liberty as prayed for.
My lord.
Think about it and do it.
My lord, my lord. Obliged, my lord.
We have not yet started the hearing. Yes,
May I please, your lordship, it's a matter regarding PH department. Already I am the landowner. And as usual process, those who donate the lands here have got the at least grade 4 post, Lordship. But still I am not getting, that's why I pray before this court.
There is no provision under the law.
No provision, Lordship.
If it is your land, it has to, you have to, they'll apply, invoke the power of eminent domain, acquire the land, pay compensation as per the law. No appointment.
No provision, Lordship, it is clear.
So,
Lordship, kindly direct them, dispose my
what?
representation.
What representation? How can we direct them to consider a case against the law?
In their oral assurance, I can give my.
Oral. Even if,
One
even
bigger
if,
cake
if
cut off.
even if there is a valid agreement for that,
Lordship,
it would be a void agreement. Right.
Donation deed is there, Lordship.
It would be a void agreement.
Donation-
Because it against the law.
Kindly, Lordship, last order is.
What last order? What is the last order? What is the last order?
4/11/2024.
What is there?
No, sir. Court order, Lordship, our court.
Petitioner claim for grateful pause on the base land donation made for water supply. As per the land donation did annexed to the rate present, the deed was said to have been made on so and deed. This may have not filed any counter affidavit to the so and so, and will be still obtain approval and file counter. Yes.
I know my only instruction is there is no policy to give somebody a job on.
Yes. Law doesn't permit. How can there be, even if there's an agreement, it's a void. Void agreement.
Agreement is not there, Lordship.
Even if there is an agreement, valid, I mean, according to if it's properly entered into, it will be void.
I lost my.
You file a petition seeking compensation instead of employment. How much the area?
One bigger 10 kata lots.
It's a huge.
And also there is no landed property. We have only home is there.
Huh?
Only home we are staying. And it is our
Only
plowing
home.
land,
Only-
roadside. In roadside land, those we already give them. Lordship.
We'll give you a liberty to approach them for compensation. Acquisition and compensation. You approach them, not for employment. Employment is not possible.
How much time we?
Yes, you have acquired the land.
That needs to be determined because that is just.
So yes, I'll ask I'll give you liberty to approach the authority. Whatever claim in accordance with the law.
It will be examined.
All right. We'll close it.
Okay.
You withdraw it.
No, no.
We'll give you a liberty to approach them.
It is better, I think.
Huh?
It is better.
Better.
Lordship.
Heard, Mr.
A.H. Alamgir. A.H. Alamgir. Lordship.
Alamgiri. A.H. What it is? Alamgir, Learned Counsel for the petitioner. Now, Mr. A.H. Alamgir, Learned Counsel for the petitioner, submits that he may be allowed to withdraw. What?
Liberty to approach them to.
Liberty approach, in the sense, then we'll have to dismiss your writ petition. We'll just say, huh?
Close.
No,
Madam,
heard,
maybe-
Mr. Huh?
Maybe written close, Lordship. Close the petition.
Then in heard Mr. H. Alamgir, Learned Counsel for the petitioner, and also heard Mr. I. Bortakur, Learned Standing on PHE. Next para. Matter pertains to claim for appointment as grade for in appointment, claim for appointment
Grade 4.
in the grade 4 post under the Public Health Engineering Department, Hailakandi Division, in lieu of land donated for Rangpur South Water Supply Scheme. Please stop.
Donation deed is page 11, Lord.
Huh?
Donation deed is 11, please.
See, number one, if you have donated, you cannot claim for anything. 20? Donation is what?
Donation 1 figure 10 kata, Lordship. Page 11, it is clearly.
Where is the
That's for one
agreement? Agreement?
It
Is there any agreement?
No, Lordship.
Then, where is the donation means what?
Actual Lordship, they are the illiterate person, that's why it is not clearly. The government has given assurance, we can give you service, give me the grant, they are providing.
This is who is this? Page 23? WC Kalashi.
It is relative Lordship, another person of another scheme, they also donate, but also they got this job, Lordship. Just showing the
Where is your donation?
page 11, annexer A, Lordship.
Relevant portion of donation deed. A fortiori, if you have donated, you cannot claim for a compensation also.
Some of the
If you have donated, what do you mean by donation? What is donation?
donation, Lordship, but.
If you donate something in lieu of you, in lieu of you cannot ask anything.
It isn't fair, Lordship. In backdoor, they are that assurance give me one service.
Very difficult. Tell us what to do. Dismiss.
Close the petition, but direction.
No,
take
no.
them to just consider anywhere.
If you are withdrawing, we may give you a liberty to approach them. If we dismiss on merit, because you're on your own saying you have donated the land. Right?
Okay, whatever is better, Lordship, kindly consider.
Huh? You decide, you tell us. You tell us. Think about it. Some other day we'll think of next week. Next week. Next week. All right. Heard so and so, huh? Good. On the prayer of Mr. Alamgiri, learned counsel for the petitioner, list this matter after a week, so as to enable him to obtain
There may
instruction.
be file affidavit, Lordship.
What affidavit? Affidavit is not required. Think about it. Either I'll dismiss on merit or you withdraw it. Will provide you a liberty to approach them whether you get it or not. Because I thought there's an agreement to, provide you employment.
It may be withdrawn, Lordship.
Huh?
I may not, it is 2018 matter, how much we suffer, Lordship.
You become more wiser now. Then you're right, huh? Mr. So-and-so, learned counsel for the Alamgiri, phrase for withdrawal of the petition with a liberty to approach the authorities in accordance with approach the authorities, the appropriate authorities for any for the grievance of the petitioner as may be permissible under the law. Huh? Mr. I. Bortakul says, then standing council says, PH is present. Prayer for withdrawal is accepted. Accordingly, representatives close on withdrawal with the liberty to approach the appropriate authority as may be permissible under the law. We did. Why this?
Is the malad recovery of malad.
Why these all matters are listed in the, admission and why the
listed
comparatively new matters, say 23, 24, 25 listed in hearing matter? What is the policy?
policy malad? It is malad initially malad rule was issued malad. That's why malad it's for hearing malad.
Not the policy, what is the procedure, what I'm trying to say?
Malad.
Yes,
And matter pertains to malad recovery of some amount malad after retirement malad. It is admissible under the law malad. In Supreme Court malad Rafiq Masih case, it is squarely covered malad. And the respondent filed affidavit malad already admitted malad.
yes. Admitted what?
Admitted regarding malad due to
That's
malad
the recovery is wrong.
recovery is not wrong, but is admitted that malad due to some malad pay fixation. But malad pay fixation malad recovery overpay allowance was malad. Kindly say malad affidavit in opposition filed by the respondent number 5.
Hmm.
6. 5 also filed malad.
Hmm. So,
Paragraph number 6 malad. The answering deponent back to state that admitted that service book right was maintained by
you are reading which page?
page malad 58 malad.
Huh?
58 malad.
There is no page 58.
It filed by respondent number 6.
There is no page 58. Is there?
Yes, here is.
Only 5. Is
May
up to
not be on the
55.
record, my lord.
Huh?
It may not be on the record, my lord.
Find out. Its record is up to 55. In a court's record, its page number is up to 55.
55.
And there's no affidavit of respondent number 6.
My lord,
Only respondent number 5.
I have received on 29/1, my lord.
But next-
2021.
Yes,
No, no, 26, my lord. 21 or
Respondent-
26.
Respondent
21.
6 filed. Respondent number 6
So,
filed.
madam, what is your stand? You
Ours-
will allow the writ petition, you refund it. You have already recovered. Just read, huh?
Deponent respondent number 6 admitted that service book of the petitioner was maintained by the Office of Drawing and Disbursing Officer. Thereafter, proper scrutiny and enquiry was done, and it was found that pay fixation was wrongly recorded in service book of the petitioner. It was a clerical mistake, and authority has to write correct it when it comes to the knowledge. So I admit it.
Whose fault?
No fraud, no.
Whose fault?
Department.
There is no,
Department.
no fraud, no misrepresentation,
Misrepresent-
nothing. So it's department's fault.
Therefore, they have a-
So therefore, you refund it.
Yes.
You refund it. You
Not a-
refund the money which you have already, recovered.
Recovered.
This lordship,
Huh?
the matter is already sub.
No, they will direct you to refund
Yes, yes,
immediately.
yes, definitely.
Okay. Yes, get that, how do you get that affidavit?
Registry,
Registry, my lord, but it already filed, my lord, not on record, my lord.
I have one extra copy, lordship.
Just provide the extra copies. Where's the order of recovery?
Recover, my lord, kindly page 25, my lord.
25. Heard Mr. K.R. Pathgiri, learned counsel for the petitioner. And also heard MS, Standing Council or State Council? Standing Council, Health Department. For respondent 1, 4 and 6. KK Medi for respondent number 5. Then SS Roy.
Finance.
Are you there? Okay, who is for 7?
7, finance department, my lord, may represent.
Treasury officer.
Finance.
Choliha.
चलिए अलाम सर हाँ. By filing this writ petition, the petitioner has put to challenge the action of to challenge the sanction letter dated 04/07/2023 issued by the senior accounts officer
In the office of the accountant general.
office of the principal accountant general Assam, whereby an amount of rupees, how much?
1,50,200.
Where it is?
My lord, left column, my lord, other government dues. Rupees 1 lakh, overpayment of pay and allowance, recovery head.
While sanctioning the
1,007.
huh?
No.
Below the underline one of the pension.
No. This is,
Some amount
please
of
acknowledge
adjustment.
the receipt. This is the total amount.
Total amount, my lord.
No, please
Adjusted.
acknowledge the receipt. Rupees 7,27,000 is to be recovered from area and future relief. This is what?
This is, my lord, some already adjusted, my lord, from the, my lord, DCRG and some amount, my lord, directed to be recovered, my lord, from the area.
So the,
Accordingly, my lord, 1,50,000 is already recovered, my lord.
this, what about this 7?
70,788 is to be recovered from the area and future relief.
This 1,000 then in this.
My lord, total amount 1,50,000, my lord, and my lord, some amount adjusted from the gratuity, my lord, DCRG, and some amount, but that amount, my lord, adjusted from the other benefit leave encashment,
It has to be adjusted, recovered and adjusted in future relief.
my lord.
And already 1,502 has been already recovered.
My lord.
While sanctioning the gratuity and other entertainments has recovered rupees 1,50,200. Are you sure?
Sure, my lord.
So will not say anything on 72.
Already recovered, my lord, my lord, on this regard, my lord, respondent number 6 filed, my lord, affidavit stating, my lord.
Per affidavit.
Patkari, I'm asking you, how much of amount you are, aggrieved? But direction was issued to recover the overpayment allowance from this end.
My lord, kindly see, my lord.
Okay,
affidavit
will
filed by
not
the-
stay, will not enter into 72, something like that, huh? Will not say anything on this,
My lord.
huh?
In this regard,
Whatever amount left.
Please stop, huh? And no, the petitioner has prayed for a direction to refund the amount of rupees 1,50,200 to the petitioner. Next paragraph. The petitioner was working as, the petitioner was initially appointed as GNM nurse,
Nurse, my lord.
GNM nurse
My lord.
in the office of the chief matron and head officer Mangal Day by the order dated 08/11/1992 and was promoted as sister tutor as nursing training center at nursing training center, Saboti, Lakhimpur in the year 2012, and finally promoted as assistant matron in 2018. List of the petitioner had retired on 13/11/2022 on attending the age of superannuation. Good stuff. The on retirement, after the retirement, the pension papers was submitted to the respondent authorities, which was forwarded for releasing retirement benefits and releasing retirement benefits, including monthly pension. List of the pension proposal papers were duly sanctioned and according the provisional monthly superannuation, provisional monthly pension as well as provisional gratuity was what I said. Also sanction. No, you said that there. The concerned authority has sanctioned the provisional pension as well as provisional gratuity in favor of the petitioner. You're right. Thereafter, after scrutiny, thereafter on scrutiny of the pension papers,
Yes, sir.
the EPO by number 923113053001, para 6, page 7, number was issued in favor of the petitioner. This para 8 is what?
Right of lead petition.
Yes. No, page 26, annexure 8.
Page 26. Subsequently, my lord, pension payment order, my lord, was
Okay.
issued, my lord.
Then recovery is page 25.
25.
The respondent authorities by dated, what is the date of this order? Page 25.
25 my lord, above my lord.
Four.
Dated 4/7/2023.
4/7/23.
4/7/2023 issued by the senior accounts officer, office of the principal accountant general within bracket Assam. Has directed the treasury officer, Lokhenpur, to recover, adjust a sum of rupees 1,50,200 on account from the gratuity and area and future relief on account of wrong fixation they pay of the petitioner. Mr. Pursuant to, no, comma, pursuant to which the treasury officer has adjusted the amount of rupees 1,50,200. List of next para. Mr. K.R. Patgiri, learned counsel for the petitioner. You are grade 3 or what?
Grade 3 my lord.
Matron is grade 3.
Grade 3 my lord.
Who is the submits that the petitioner who has retired as grade 3. Ought not to have been allowed to suffer by illegally recovering by way of illegal recovery of rupees 1,50,200 due to the mistake on the part due to fault of the respondent authorities in fixing the pay of the petitioner while she was serving. Mr. While referring to the while relying Mr. Patgiri placing reliance on the judgment of Honorable Supreme Court in the case of State of Punjab versus Rafiq Masi in bracket white Western bracket close 2015 for SCC 334 submits that the respondent authorities would not have recovered the amount recovered and adjust the amount, appropriate amount from the retirement benefit, including the gratuity, on account of the fault of on account of mistake in fixation of the pay, as the fault lies with the respondent authorities, and there is no misrepresentation or fraud played by the petitioner. Therefore, the recovery is illegal and the respondent authorities are may be directed to refund the amount of rupees 1,50,200 forthwith. Mr. M.S. So-and-so, learned counsel for the learned state standing counsel for health department, while referring to the affidavit filed on behalf of the respondents, submits that pursuant to the letter, impugn letter for recovery. Come on. Pursuant to the sanction of death cum retirement gratuity No, sorry. Pursuant to the impugn sanction letter, comma, the and whereby it provides, whereby it has directed to recover the amount of rupees 1,50,200, comma, same has already been recovered from the petitioner. List of she submits that it is an admitted position that the service book of the petitioner was maintained by the office of the drawing and disbursing officer. And on proper scrutiny and inquiry, it was found that the pay fixation was wrongly recorded in the service book of the petitioner, which was a clerical mistake. Therefore, the same was corrected when it came to the knowledge of the responding authorities. List of. She submits that there is no fault on the part of the petitioner, as the petition has neither as there's no misrepresentation or commission of fraud on the part of the petitioner. List of. That's all. You have recovered, but then there's no fault on the part of the petitioner. Consider the submissions of learned counsel for the parties, and also peruse the materials available at the court. And peruse the material, peruse the materials available on the court. The petitioner had retired as grade 3 employee from the grade 3 under the Department of Health and Family Welfare, Government of Assam. On, just give the date, on 9 on 13/11/2022. List of. By the impugn section of the authorities has directed.
So it is mainly
Concern-
respondent number 6.
Concerned authority to recover sum of rupees 1,50,200, being the overpayment of pay and allowances to the petitioner, which pursuant to which they said the amount has been recovered. List of. As submitted by the learned counsel for the parties, the overpayment, if at all, overpayment of pay and allowances to the petitioner during the lifetime, during her service appears to be due to mistake in pay fixation of the petitioner, which no fault can be attributable to the petitioner. The pay fixation, if any, if there is any mistake or wrong in pay fixation, would be due to the fault or mistake of the responding authorities. list of the authority obviously would have the respondent authorities obviously would have the power and authority to correct a mistake. However, unless the mistake or fault is attributable to the petitioner, same cannot be. No recovery if no recovery ought to have been made from the petitioner. List of the law on recovery of excess public overpayment of pay and allowances and its recovery from the employee, particularly grade 3 and 4 employee, has been settled by the Honorable Supreme Court. In the case of State of Punjab, in the case of Rafiq Masi, what was Supra, the relevant paragraph is quoted here in below, reproduced here in below, para 18. Okay, he is quoted in para 9, para 18 in the request. In the present case, record reveals the records reveals in the present case, it is seen that the wrong fixation of pay and allowances of the petitioner was on the part of respondent authorities. List of the recovery, the mistake of wrong fixation has not been, appears to have not been corrected during the service of the petitioner. However, same is sought to be recovered. Same has been recovered after the retirement of the petitioner. That too by adjusting from the adjusting from the pension retirement benefits, gratuity, etc., which would not be permissible under the law in view of the fact that the petitioner has retired as a grade 3 employee. Retired as a grade 3 employee. The such no. The respondent, the learned counsel to the state respondents fairly submitted, fairly, no, that you record, not same. To step does the recovery of so and so is not is not sustainable, and the respondent authorities are liable to refund the amount of so and so to the petitioner. Next period. In view of above, In view of what has been discussed here in above, the I'm of the considered view that the recovery of rupees so and so from the retirement benefit of the gratuity, etc. on account of at least wrong fixation of pain allowances. You know, overpayment on account of wrong fixation, the pain allowance of petitioner is not permissible under the law. Mr. Thus, the petitioner is entitled to be refund an amount of rupees so and so to the petitioner. Accordingly, it is directed that the responding authorities who will refund respondents.
Joint
particularly
Director.
Respondent number 4 and 6 shall refund an amount of rupees 1,50,200, which has been illegally recovered from the petitioner. Recovered in the alleged overpayment of pain allowances on account of wrong fixation of the pain allowances. Rate petition stands allowed and disposed of accordingly. Okay. Yes, Mr. Chaudhary.
Look, that series,
What series?
there's a series that starts from 34. I am appearing in some of the matters for IOC.
Okay.
We can-
30?
34 to 41, supplementary list.
Okay. How long it will take?
Depends on the petitioner.
Item 36, my lord, I am appearing for a petitioner. We have filed an implement application for implementing
No,
the.
it's listed for hearing.
Yes, my lord.
Okay, we'll see at 2.
28 and 30 law.
Huh?
In item number
29 to?
29 to 32, there are 4 matters, Lordship. I am appearing in 29 and 31, where Lordship, my affidavit is not on record, Lordship.
Call, we'll see it, we'll take it up. Not today.
Lordship, we have not filed yet, Lordship.
You have not filed.
My lord, in 2 items, they have filed, all are same issue, my lord.
This is what?
29 to 34, my lord.
Take time. Process.
We're rising it to 3:15.
That's why, Lordship, come out after 3 weeks, Lordship.
Why
because
3
I-
weeks?
I have not filed my
We'll
affidavit.
take up at 2.
Yes,
We'll see,
please.
we'll see, take up at 2.
Two petition are ready.
Indulgence, Your Lordship. Your Lordship, the item number 33, I am appearing in this matter. Your Lordship,
No, this is item 29 to 33.
number 33 is concerned.
32, sorry.
33.
Huh?
I'm
Last-
paying for
last
some
item.
accommodation, Your Lordship, the next week, Your Lordship.
Next week not possible.
10th of
What is the matter?
Related, they are claiming, Your Lordship,
minimum scale of pay, my lord.
minimum pay.
As per the judgment of the division bench, open thus, my lord.
The
The 10 years of service is completed.
How you were appointed?
2000.
How you were appointed?
Through due procedure, my lord.
How? What is due procedure?
The interview advertisement was published in the written interview, as well as Viva.
So minimum pay scale, what's there? It's settled.
Contractual employee. Your Lordship.
It doesn't matter. Scheme is over.
Still continue.
Then is another scheme.
This case.
Scheme is continued. They are working like a permanent.
No, if it is a scheme, then it's a particular scheme. Already state government,
It is state government scheme.
which department?
The center, the PNRD. Concert and Rural Development.
Who are inclined to grant, allow,
Not this matter.
after 2 weeks. I'm inclined to allow the writ petition. Minimum pay scale. Minimum, how much you are getting now?
22,000.
22. This is more than minimum. What is the post?
The junior engineer.
Okay. Scheme, another scheme. Let us say after 2 weeks. Heard Mr. So and so. learn
Date may
concept
be,
for the
date may be
petition.
fixed, my lord.
On the prayer of Mr. K. Corlan, Additional Advocate General for the respondent state. Let this matter be listed after 2 weeks.
Date may be fixed, my lord.
Give the date to you after 2 weeks.
And 30 lordship, I have not filed my affidavit lordship, it is gone for waiting, not yet received.
This is what,
Not termination. Major
huh?
Stoppage of
increment.
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 So,
For
which
2
which
years.
case you have filed the affidavit?
My lord, only one.
30 and 32. 29 and 32 you have not.
9 and 30.
Which case you have filed?
31 and 32. They have filed.
20.
30 and 30. 4288 and 429 you have filed. Then 29 and 31. You
Common issue, my lord.
heard, Mr.
My lord, only one submission matter.
Same order. Is it a same order?
My lord, same allegation on the same set.
Forget about the allegation. Same order or what?
No, department.
Then,
Separate.
then separate order.
Yes, my lord. Several.
There
times,
are
yes.
discipline proceedings.
Yes, my lord.
Then
My lord, the.
you are
punishment
lucky that you have not been terminated.
My lord,
It's a stoppage or increment. It's a major penalty.
my major punishment for 2 years. my lord.
Initially, you were imposed a
Minor
penalty
punishment, then it has enhanced.
on your appeal.
On, yes, my lord.
Who asked you to appeal?
No, I have not, show cause necessary was issued, my lord, for enhancement. And my lord, he has taken time on several occasions, my lord.
Heard, Mr. I. Rafiq, learned counsel for the petitioner. It is submitted by MS S. Barua. Sorry, B. Sharma, learned CGC, that she has already filed affidavit of opposition in WPC 4288 and 4292. List of by Mr. S.S. Roy. Prays for and is granted 3 weeks time to file affidavit in WPC 4302 of 2024 and 4291 of 2024. CGC, huh?
The last.
No urgency, only stoppage of increment.
Date may be fixed, my lord.
After 3 weeks, you give that. After Holi, is it auspicious for you? Being a central government? Huh?
Yes.
Will start and whom, how?
Item numbers 34 and then 37 to 41.
34, 37 to 41, yes.
And item numbers
35 and
36.
huh.
background is like this, madam. There was a selection process held.
Hmm.
So in the petitioners in item numbers 35 and 36, they lodged a complaint with us saying that they have been wrongly ousted from the selection process because they are entitled to some additional marks in terms of the advertisement.
Hmm.
Some relaxing. Now, once these two allegations came and they also simultaneously filed the writ petitions, we did an internal inquiry with the IOC. And we found that not only in respect of these two posts, in respect of a few other posts also, there were some errors in calculations and some errors in the selection process. So what we did was the erroneous selections that were detected, we terminated them. So the second batch of writ petitions, that is 34 and then 37 to 41.
They were all selected and they were working
They were working.
for 1 year,
Ah.
nearly 1 year. And
then,
the probation is for 6 years. I mean, 6 months.
no, they claimed that it is income, but in terms of the advertisement, it was one year plus extendable. I mean, it has to be, there has to be a specific order of confirmation in terms of the terms of appointment.
Hmm.
They were never confirmed. That is a admitted position. Now, once we detected that these were the anomalies, we conducted an internal exercise. And that exercise led to this revelation that there were some errors in awarding marks and all that. So these terminated candidates are also before your law. So these are the two sets of writ petition. In 35 and 36,
What they want?
they are saying that they ought to have, they could not have been excluded from the selection process because they are entitled to certain relaxations in terms of the advertising.
Hmm.
So this is, in a nutshell, this is what it is.
So-
Depends on how they want to proceed.
In item number 36, my lord, we have filed an application for impleading the unreserved candidate. There are two unreserved candidates. My lord, we have applied for the post of junior engineer assistant 4. And there is, my lord, the 5.
No, where this item 36 is?
Item 36 is WPC number, my lord, 8082 of 2022.
Hmm. 8082.
Yes, my lord.
This is for implement of what?
Implement application number is 3711 of 2025.
Hmm?
3711. IS civil, my lord.
Ah. For
impleading, my lord, Jintu Deka and Mrinal Deka, they are the unreserved candidate appointed in the post, my lord.
okay.
There are
So-
5 posts advertised, my lord,
Hmm.
and
So this IA has not been allowed. It has
Sir.
not been disposed of.
no, man.
Then what about other IA?
Other, my lord, the IOCL, my lord, for
Other IA? Chief
there
Business
are
Officer,
IAs, my lord,
Union of India.
for striking down their names, my lord.
Okay. Hmm. So unless, see this item 34 and 37 to 41 are the same selection process.
Yes, yes.
Posts are different. Selection process is the same.
Post are which post? Junior engineer. Junior-
34 to 36, junior engineer assistant 4, 34 to 36. Baki kitna hai?
34 to 30.
36.
The disciplines are different. Otherwise, junior assistants.
So there is no, I mean, see, for 34, 37 and 36, so far as the posts are concerned, it's not the same, same post.
36
Are same, my lord.
for the same post.
No, no, 35, 36 same, but the rest whom you have terminated, they're different posts,
Yes,
Yes.
different discipline, not the same post.
No.
except for 34.
Huh?
34, my lord. That is PNU division.
Just to
So-
clarify, my lord. Item number 34 is junior engineering assistant
PNU.
PNU. Then 35 to 37, I think, 36 are junior engineering assistant production. This is the same post. And then there is another post, the last item, junior engineering assistant, fire and safety. All pursuant to the same. advertisement.
Same advisory with different post.
Different post, that's most.
The petitioners in item 34, 35, and 36, they are for the same division, which is the PNU. And therefore, among the three, one has to hold the post. Insofar as the other items are concerned, those are not arising out of this particular division, and terminations also have been done on different grounds. PNU division, the only contest was age relaxation between petitioners in 34, 35, and 36. Rest, my lord, there are different grounds, maybe alteration of mark sheets, etc. So, and they are against different divisions altogether.
So can it be heard? 1 hour.
I may kindly be considered, my lord.
1 hour, huh?
I.
Today, your lordship may.
I may kindly be considered.
Yeah.
Or my.
I for implement.
Implement, my
That
lord.
may be decided.
So we'll have to.
The notice has to perhaps go.
No, we'll implement them and notice.
Yes, my
will
lord.
send.
Yes.
That,
You-
in those
Whom do
two.
I want to implement.
Your lordship, we are raising
My
an
friend.
objection, on the impleement of the two candidates, two people who are working in the corporation as of now. That grounds for implement of those two people is this, that they are into the general category. The other side's clients are on the OBC category. There were one seat in the OBC category, 3 people are contesting those.
You are objecting.
Yes, I'm okay.
So let's notice, let them file objection.
They have already filed their objection, my lord.
Okay.
If they wish to file a rejoinder, they can, but we have filed our response to the
So
application.
it can be decided today.
That matter, those two matters, that matter I'm not. What, I.
Good, my lord. My lord, there is an advertisement, my lord. It is-
yeah.
it is- My lord, a read petition, the advertisement, my lord, you'll find at my read petition, my lord. 8082 of 2022, item number 36.
It's okay. You just tell us why they are a necessary party here? Whom you are seeking implement?
My lord, page number 5, opposite parties number 7 and 8.
7 and 8.
Yes, my lord.
Jintu Deka, junior
Deka
engineer
and
assistant,
Mrinal Deka.
Mrinal Deka, junior engineer assistant. Yes.
My lord, 3 posts were advertised, my lord. The petitioners of item numbers 34, 35, and 36 belong to OBC category, my lord. Out of 3 posts, 2 posts was unreserved and 1 post was earmarked for OBC. In this selection process, my lord, in the written test, the petitioner in item number 35, he scored 93 marks. And my lord, petitioner in the present case, he had scored 79 marks. So, my lord, out of 5 candidates, we have scored the highest mark, my lord. Whereas the petitioner in item number 34, Sri Pranab Pathak, he scored, my lord, you'll find at page 8 of the IA, my lord.
He's there already.
Yes, my lord, page 8.
Pranab Pathak is a respondent there.
Yes, my lord. He is the respondent here, my lord, and a petition in item number 34.
Hmm.
This Rahul Das, he got 93, my lord. Prasant Kumar, the petitioner in the present case, he scored 79. Pranab Pathak, 73. They are all OBC category candidates, my lord.
They're all OBC.
Yes, my lord.
General is.
General, the
70.
next page, my lord, Sri Jintu Deka and Sri Mrinal Deka. They have scored 72 marks, my lord. My lord, although, my lord, we have been selected, we have been appeared for the OBC category, my lord. My lord, as a law, my lord, it was reported in 2007, 8 SCC 785. Paragraph 9 may kindly be perused, my lord.
What
Although
do
we
you
have
say?
been
Tell
complete
us.
for the OBC category, we may be selected for the general category, my lord.
That is
Yes,
settled.
on,
no?
on that basis, my lord, we have filed this IA, my lord.
It's been decided long time back and
Yes,
it has
yes.
been reiterated recently.
Yes, my lord. Paragraph 9 may kindly be perused, my lord. That page 7.
Last week, 2 weeks back. I think last week or
Yes, yes, yes.
10 days back, it has been reiterated by the Supreme Court.
Yes, madam.
Yes, madam.
Your Lordship, as far as the advertisement in the present subject matter pertains, if I can take your Lordships to item 36, brief, the advertisement is at page, it starts from page.
You have not put it in your objection. Where is the objection? Objection? There's no objection. Have you filed the objection? It's not.
Start at page 15, my lord, in IA, page 15.
Huh? Page 15?
Page 15 starts, my lord.
There's no page 15. It's up to 14. Objection in IA.
In IA, my.
Anyway, you just tell us.
Your Lordship, I'm referring to the advertisement. The advertisement has a clause. If I can take your Lordship to clause G of the advertisement. Clause G2 of the advertisement states that maximum 18 years and maximum age shall be 26 years for general category candidates. Now, the other side, candidates are OBC candidates and they are exempt. Their exemption is there in the age limit. That is plus 2 years if they are OBC candidates and plus 1 year if they're OBC and plus 2 years if they have an apprenticeship certificate. Now, in this case, even if they avail those age relaxation as per the clause given in the advertisement, the age relaxation under the OBC category gets knocked out because now they want to take advantage of the general category position that is there in the advertisement. But the general category advertisement only prescribes 26 years of age. At the time when they applied, they were 29 years of age. So even otherwise, if the impleaded parties also come here, then also they will not be eligible to apply in the post of general category because they are overage in that sense. So impleadment, even if it allowed, I really doubt if it will help their client in that perspective. That is my only objection to this as per the advertisement.
No, according to as per the advertisement, they are overaged.
That's the main contention in the main writ
So
petition
for
also.
general category, it was
6 years. Your Lordship.
maximum.
Yes, maximum.
And
If general category, if you are an OBC candidate, you will get +1 and +2 years. If you are an OBC plus, there is apprenticeship certificate if you have from the corporation or.
so you have rejected the petitioner on the ground of overaged.
Place, our understanding of the advertisement was that dual benefit of age will not be given. Either you take the benefit of age relaxation under OBC or you take the benefit of apprenticeship certificate. That was our understanding while we rejected their candidature initially. However, when the vigilance inquiry took place, it was the vigilance noted that dual benefit had to be given. Therefore, the other third person that is contesting the matter here got terminated on that ground as well, that you are not fitting in the age. Therefore, there is a termination order in that respect. Now, all the 3 candidates who are contesting for OBC
Let us
are out right now.
Let us see the advertisement.
Please, Your Lordship.
Where it is? Which thing?
At
Which
page
writ
27,
petition?
item 36, page 27 is the advertisement and relevant page 33.
36.
Age rate.
808.
item.
Huh.
Your Lordship.
Page
Clause G.
yes.
Clause 2.
Hmm.
Which says minimum 18 years and maximum age shall be 26 years for general candidates as on 30th/9/21. G3, relaxation in age up to 5 years for SC, ST and 3 years for OBC candidates considered against a reserved position will be allowed. Your Lordship, if I can straight away take you to clause 8, subclause 8. age relaxation of a period equal to minimum years of experience notified against the post shall be allowed. Further, period of apprenticeship training in any industry covered under the experience criteria notified in the advertisement relevant to a post may be considered as experience. However, in such cases, relaxation towards age shall be available.
Shall not be.
Maximum
Shall not be available.
clause,
If you
subclause
omit,
10.
if you omit the note, then it's meaning will be different.
Subclause 10, maximum relaxation of 1 year in age will be given to candidates possessing boiler competency certificate and being considered for the post code 202. The post code in the instant issue is 202 and the other side also has an apprenticeship certificate for boiler competency certificate. They possess that. It's an admitted position. So today, if they want to shift from OBC to general category, your lordship, then subclause 2 is going to hit.
Why?
Your lordship, now they want to contest for general category. General category age is 26 years.
No.
As on the date when they applied, they were 29 years, your lordship.
This is so far as for application.
Yes.
For to apply the post. Once they are allowed to participate, when you have not rejected them on the ground of age, how you can reject them now? So once this will be on the merit only.
But your lordship, they're not fitting the age category
No.
criteria as on date, your lordship.
Why?
I'm reading clause
See,
3 2 of this.
see, that time they were 29 years. Maximum for a general is 26. 3 plus 6 plus 3, 29.
Your lordship.
Yes. That is the at this stage of accepting the application.
Yep, I bow down.
So once you have allowed to participate, when you have not rejected them on the ground of age, right? And in fact, relaxation is 3 years, isn't it? So if they were 29, they were eligible to participate. Accordingly, they have participated and they scored higher than the general candidate. So if it is the case, they cannot be treated as the reserved category.
Your lordship, I'm understanding what is falling from my lordship. My only argument is this, that the general category is 26 years. When they applied at that relevant point of time, they were 29 years. They were fitting in that age criteria at that relevant point of time
Relaxation.
under OBC category. But
See,
if they would have been general category, they would have been ousted from this process because they had crossed 26 years.
When apart from this, you saw that this is age limit relaxation for candidates belong to SC so and so, right? What is the how you distribute the post? How many posts were there? We'll have to go to that. Then these posts are for what? One is for general.
2 is for general.
Huh?
2 is for general, 1 is for OBC.
OBC. So in which post they are claiming now?
Now they wish to come to the general
The
category,
general category.
wherein the people are
See,
already.
That is what you are trying to say is other way around. It's reverse. As if you have kept a reservation for general.
No,
General
that-
means
that-
is open to all.
No, yes,
Right.
general category seats is open
Right.
to all. I bow down to that. Yes.
Then, if you say so, if they are trying to claim the post of general category as if it is reserved post, isn't it? This clause G and all this will apply only for eligibility to participate.
Please, your lordship.
All right.
Yes.
Let them contest. They are working.
Yes, Lord.
Okay. Her mister will allow. So you cannot appear for him. I mean, you cannot appear for this respondent. You are for all India.
Notice has to go, madam.
You are for all India. Indian only. Yes.
Notice has to go.
Her Mr.
RM Deccan.
RM Decca, Learned Counsel for the petitioner, the applicant, writ petitioner. Decision, application, and also heard MS.
Tarshna Singh.
Learned Counsel for opposite party, Indian Oil Corporation. Opposite party of the India Corporation. This is an application seeking implement of Sri Jintu Decca and Sri Mrinal Decca as respondent number 7 and 8 in connected WPC 8082 of 2022. List of next para. The applicant of the petitioner has filed a writ petition. It has filed a connected writ petition challenging the selection and appointment of selection and appointment of the selection and appointment in the post of junior engineering assistant dash Roman 4 within bracket PNU bracket close in the Guwahati refinery pursuant to the advertisement dated
25/9/2021.
25/9 page 33
Page 27.
uh
Page 27, it starts, my lord.
okay
Right hand side, my lord.
pursuant to the advertisement dated 25/9/2021 whereby among others an application was invited. Among others applications whereby applications were invited among others for filling up the junior post of junior engineering assistant. That's for Roman 4, same. Let's take it from this serial number 202, page 27. In the Indian Oil Corporation Limited within bracket refineries division bracket close. The you are not selected.
No, my lord.
The applicant was not selected despite he scored 78 scored marks, scored the total marks of 70. You are 73. Pranab Pathak.
79, my lord.
Okay, 79.
Pranab Pathak is the private respondent, my lord.
Huh?
Pranab Pathak is the
Okay.
respondent number 6.
79.
The applicant got 79,
Although,
page 37.
being OBC NCL category list of the persons, the above named persons sought to be implemented have scored the general candidates, were the general candidates who have scored 72, total 72 marks each, 72 marks respectively. However, they have been selected and appointed as so and so, junior engineering assistant so and so, so and so. List of, according to the petitioner applicant, next para, since the applicant petitioner has scored higher marks than the general candidates who have been appointed, comma, the applicant ought to have been selected and appointed in the said post. List of next paragraph. Mr. R.M. Dekar, then constable, the applicant submits that since the appointment and the selection and appointment is under challenge pursuant to the advertisement wherein the above two persons who have been selected, including the above two selection and appointment of above two persons, comma, both the persons are necessary party in the for proper adjudication of this present adjudication of the connected writ petition for which their implement is necessary. Therefore, he submits that the applicant may be allowed to implement both Mr. Sri Jintu Dekar and Mridul Dekar as party respondents in the connected writ petition as respondent numbers 7 and 8.
Yes, ma'am.
7 and 8. Mr. Next paragraph. MS so-and-so learned counsel for opposite party. Oil India. What is Indian Oil Corporation? While referring to the referring to the advertisement, particularly as regards the age limit oblique relaxation for candidates belonging to SC, ST, oblique OBC within bracket NCL, bracket close oblique PWBD, oblique EXSM. Submits that the applicant is an OBC candidate who has availed the age relaxation of 2 years, whereas the minimum age, whereas the maximum age for the general category candidates is 26. List of, since the applicant oblique petitioner has availed the age relaxation of 3 years, comma, he would not be entitled to claim for the post under general category. Right. Therefore, even if the above two persons sought to be implemented, comma, and comma, the respondent, the applicant would not be entitled to claim for the post on which the two persons have been appointed, selected and appointed. Therefore, the above two persons are not a necessary party to be included in the connected writ petition. Next paragraph. I've considered the submissions of land council for the parties. Next paragraph. Upon perusal of the advertisement, particularly with regard to age limit and relaxation, comma. It cannot be, it would not be, it cannot be said that once the reserved category able the age relaxation, comma, he would not be, he would be barred from competing the post under general category as it is as the position, as it is certain that the reserved category candidates would always be competent, would always be allowed to compete with the general category. List of the applicant having been scored more marks than the general category, comma, prima facie, in terms of the, in view of the settled positions of law, comma, the reserved category can be appointed in a post under general category, as it cannot be, it is not the law, it is not the, it cannot be said that once, it is not the law that, no. It cannot be said that the post under the reserved category is treated to be a general category, cannot be treated as a reserved post, which is it is only the reserved post which is particularly reserved for the ST, no, which is exclusively for the reserved category. Next paragraph, having considered that the petitioner applicant has challenged the selection process pursuant to the selection process which has been undertaken pursuant to the advertisement that is so and so for filling up of various posts, including the post of junior engineering assistant. That's called so and so. Pursuant to which the above 2 persons have been appointed in the said post, considering that the petitioner, although a reserved candidate, appears to have scored higher marks than the above 2 persons who are the general candidates. I'm of the considered view that the above 2 persons having been selected and appointed in the said post, in the pursuant to the selection process which is under challenge, they would be a necessary party for proper adjudication of the connected writ petition. Thus, they are entitled to be heard in the proceedings, in the connected proceedings, accordingly. The above 2 persons, namely so and so, are allowed to be implemented as party respondent number. Party respondents number 7 and 8.
Yes.
in the connected so and so, writ petition so and so, writ petition stands. The IA stands allowed and disposed of.
My lord, liberty may kindly be given to file amended cost title and prayer.
Obviously,
Yes.
in the writ petition, huh? In view of the order passed so and so, registered to incorporate so and so, then issue notice to the newly implemented respond number 7 and 8. Petitioners to take steps for service of notice upon so and so by speed post so and so. Then in that case, we'll list the matter after 3-4 weeks.
I have a small prayer, you know.
Yes.
In fact, in one of the last orders, liberty was granted to make a prayer for de-tagging. Lord, now your lordship has seen insofar as these, the entire batch was partially heard and then released because of this development, my lord. Now, insofar as item numbers 37 to 41 are concerned, my lord, they've got nothing to do with either age relaxation or migration from OBC to open category, my lord. Those terminations are on different footings altogether. So, because of this.
We have an objection to that for the simple reason. It is because of item numbers 35 and 36 that the whole thing got opened up. And those complaints, etc., all those pleadings are in item numbers 35 and 34, 35 and 36. So those have a kind of bearing on the other cases. So therefore, I feel that, and since it ultimately arises out of the same selection process, it might lead to some.
We'll hear, obviously, they will not hear only the petitioner in one writ petition. We'll hear all the petitioners together.
The only anxiety is they'll come, they'll file affidavits, my lord. It was a part heard matter. These matters linger.
Who had
It was released, my lord.
It was released. It was released because of.
Released, then cannot help it.
Correct.
Because of this development only, it had to be released.
The circumstantial hazards.
Now 37 to 41 has to wait again.
Can't help it. Watered and released, I mean, that is something circumstantial hazards. Can't help it. Keep it, we'll hear all of you. Maybe on the same day. We'll continue other day also. We'll keep it together. Because what he may be correct.
Right.
You said that on the basis of the two complaints of 2 persons would have notice and other thing who have been terminated. So would like to see at the same time, because these 2 persons is also before this court.
True.
They have also.
But essentially their grievance was no age relaxation. They have got nothing to.
Maybe that may be different, but the basis, the things were set into motion because of this
That could
two
be correct.
petitioners, right? So I think.
May I just pray for a fixed date?
19th March.
Make it 4 weeks. You have to take steps, huh?
My lord, liberty may kindly be given to take Dusty, my lord. On the last occasion, he also.
And Dusty, including Dusty, huh?
And lordship permit us to file the amended cost
Obvious-
title.
Obviously, we have directed.
Yes.
You immediately file by tomorrow,
Yes.
you file it, they'll incorporate and
Cost title
notice
will
will
be
be
issued.
issued. And you take steps by Dusty as well
Yes,
as
yes,
Dusty.
yes.
You give that, eh?
12th of March, my lord.
12th,
12th of March.
I think. Okay.
That will be more than 4 weeks.
Ah. Then you said all these writ petitions. One order you passed, heard so and so, all of them. You are for,
435.
and you just tell your writ petitions, huh? Writ petition number. Just give that and then you are in?
I am in 34 and then 37.
I Chaudhary, Learned Senior Counsel, assisted by so and so for item, huh? Your writ petition situation. And you are for? Okay. So I thought you are in a different thing. Okay,
Deeply obliged.
Obliged. Your lordship is fixed it on 12th of
12th.
March.
Hmm.
Obliged.